we're going to move on to someone I'm really honored to have with us tonight, Peter T. Cavallero, the mayor's son. Now, how about this? We had Cornell a minute ago, undergraduate. Now we have number 2 in his law school class at Cornell. So Peter, I won't call him Junior because he has a different middle initial. So it's Peter T. Cavallero, the mayor's son, and he's spectacular. Thank you for having us with us.
Thank you very much. Well, Peter. Don't take this out of my time, but before I get started, I just wanted to note that what we're doing here tonight is exactly what the founders had in mind when they designed this Constitution. In their words, they gave us a Constitution for the people, not for bureaucrats or scholars, for the people. And the Constitution depends on ordinary citizens coming together to discuss it, think about it, study it. And so this kind of gathering is exactly where we're participating in a very meaningful way in our constitutional system. And so I thank Justice Legato for organizing this event. So, given that tonight's theme is immigration, and as you saw in the program, my academic interest is in history. I wanted to talk to you tonight about one of the sorrier episodes of American constitutional history, which is the Chinese Exclusion Act of the late 19th century, and a few other acts and Supreme Court cases that came out of that, which collectively have a profound impact on the current state of U.S. immigration law. In fact, if you really want to understand the current state of play in this arena, you have to go back and you have to understand the history. And I think this will actually dovetail pretty well with Ed's talk, because it fits right in there. So without further ado, let's jump into it. So cast your minds back to the 1870s. The United States had just bounced out of a bloody civil war. And while it's going to take a long time for the Southern economy to recover, by and large, business is booming in the United States, spirits are high. The country's undergoing an industrial revolution. New products are flooding the market, technology is expanding, the frontier is decreasing, new states are being added, and nothing typifies this progress more so than the burgeoning of railroads, spiderwebbing out across the United States, connecting centers of commerce, and really representing a transportation and infrastructure revolution, the likes of which we won't see again until the 1950s with the interstate highway system. And these railroads are being built by and large by a new member of the American family, which is Chinese immigrant laborers coming across the Pacific Ocean in increasing numbers in the years after the Civil War, who are working on these railroads for low pay, under very distressing conditions. And these immigrants are being met by many Americans with feelings of mistrust, anxiety, demonization. There's a real fear that these Chinese immigrants are coming and they don't look anything, they don't dress anything, they don't sound anything like most Americans had ever seen before. The idea was, are they going to come and they're going to destroy the culture, they're going to uproot our way of life? And the change was dramatic. By the end of the decade, almost 25% of the labor force in California was made up of Chinese immigrants. And many of the major cities on the West Coast had, especially San Francisco, had blocks and blocks and blocks becoming what was called Chinatowns. So to the average American, the change was happening before their eyes. And you start to see debates percolating through the legislatures in this time frame as to whether, for the first time in its history, the United States is going to ban immigrants from a country for policy reasons. And so you have coalitions arising on each side of this debate, and you see strange bedfellows, constituencies that you wouldn't ordinarily expect to be on the same side of an issue, coming together to advance their interests as to whether the Chinese should be excluded or restricted. So on the pro-immigration side of the debate, you had first and foremost the white ethnic immigrants centered in the coastal cities of the Northeast, most especially the Irish, who had come in very large numbers even before the Civil War. And these immigrants saw correctly that any exclusionary measures applied to the Chinese could boomerang back and hurt their own communities. And so they were very much in favor of an open door policy toward the Chinese. And they were joined by big business employers. Then, as today, big corporations liked unrestricted immigration. They saw it as a pool of untapped cheap labor that they could use to increase their profits. And so they lobbied very hard to keep the door open for Chinese immigrants. On the exclusionary side of the debate, you had first and foremost old Jacksonian workers and the labor leaders that gave voice to their concerns. This was the traditional heart and soul of the Democratic Party going back to Andrew Jackson, and today we would call them blue-collar workers. The fear was, as Ed mentioned, that they would come and, quote, steal the jobs. And they were joined in their advocacy by small business owners who opposed Chinese immigration for the same reason that big business supported it. And then a final plank of this coalition was a group called the Nativists, and they were just outright racist. They didn't like the Chinese. And interestingly, another lobbying force in favor of restricting Chinese immigration was actually the Chinese emperor himself, who was really not happy about the outflow of people, but at the same time, he really was powerless to do anything about it, so he was lobbying for the U.S. government to restrict immigration. And so this debate comes to a head in 1882 when the United States passes, when Congress passes the Chinese Exclusion Act. So it bans, and a couple series of acts after that, collectively ban Chinese immigrants from coming to the country. And this is followed a few years later by the Geary Act, which imposes onerous restrictions on the Chinese immigrants who are already here, most notably requiring them to carry around an ID card, basically like an internal passport to relegate them to second-class status. And just like today, as soon as these acts are passed, you see a flurry of litigation pop up to challenge the constitutionality of these acts. And just like today, the Supreme Court was seen as the ultimate arbiter of whether or not these acts would be allowed to stand. And it doesn't take long, just a few years, before a case is brought to the Supreme Court that implicates the constitutionality of the act. It's the case of Che Ping versus United States. The plaintiff in the case had been a legal resident of the United States for 12 years, and he went and visited relatives in China, and he carried with him a card issued by the government guaranteeing him a right of return. But in the interim, the Chinese Exclusion Act is passed, and so when he tries to come back into the country, he's detained in the port of San Francisco, and when he holds this card, the government says, nope, law says no Chinese immigrants allowed. And so he's seeking a writ of habeas corpus challenging the legality of his detention, and by extension, he is implicating whether or not the Exclusion Act is constitutional. So the court rules in favor of the government and upholds the act in full. And in so doing, it articulates what remains good law as to Congress's power to regulate matters of immigration. You see, right back to the very inception of the Republic, it was always understood that Congress was the branch that was primarily responsible for curating matters of immigration and naturalization, that is, natural-born citizenship. Of course, the president enacted these things, but Congress was the one that would pass policy initiatives. But it was never fully articulated from whence derived Congress's power, because in constitutional scholarship, you're always trying to locate where the authority comes from for a certain branch of government. And there was a lot of confusion on this point. But in the Chinese Exclusion Act case, the court articulates what's known as the plenary power doctrine, which says that Congress's authority to regulate matters of immigration is plenary. That is, it derives from the very essence of its sovereignty as a co-equal branch of government. And pursuant to this doctrine, Congress's authority is treated highly deferentially from the courts. And so today you will rarely, if ever, see a court step in and invalidate a broadly applicable act of Congress regulating immigration. You will see plenty of instances of courts ruling on particular cases, dealing with particular litigants, challenging the validity of their detention, trying to come in, trying to fight deportation, and the courts will rule on the facts of those cases. But because of the plenary power doctrine, you will not see, when Congress passes a law regulating immigration across the field, the court stepping in, by and large, and invalidating that law. Now, the decision in upholding the Exclusion Act was joined by Justice Harlan. Now, who is Justice Harlan? Now, Justice Harlan is lionized by many constitutional scholars as a really enlightened and inclusive view on the Supreme Court for race relations because of his heroic dissent in the notorious case of Plessy versus Ferguson, which happened a few years around this time. Now, as some of you may know, Plessy versus Ferguson notoriously found that separate but equal with respect to blacks and whites was constitutional, and it condemned African Americans to decades of Jim Crow segregation in the South. Justice Harlan writes an impassioned dissent advancing very enlightened and inclusive views against the evils of this decision. And yet here he is joining, not only joining a decision that bans Chinese from entering the country, but does so in reliance in part on the type of demonizing and stereotyping rationales that were current at the time. And it's a reminder that the United States constitutional history, and history in general, is a series of starts and stops when it comes to our understanding of who's part of the American family. we learn the lesson with respect to a particular group or a particular circumstance, but it doesn't always translate to the next group, We have to learn the lesson all over again. Like the Hebrews in the desert, we forget sometimes the lessons that we learn. So, just to continue the history, a companion case that was decided a few years later that went in the opposite direction, but which is equally impactful for the current state of immigration law, is the case of Wong Kim Ark versus the United States. Now, this is similar in the sense that the plaintiff was similarly banned from coming back to the United States, having been a legal resident in the country because of the Chinese Exclusion Act. But there's a difference in the facts here. The plaintiff was born in the United States. His parents were the ones who had immigrated from China. And so the court, in this case, ruled in favor of the plaintiff, and in so doing, it articulated a doctrine that we know of today as birthright citizenship. The idea that if you're born here, you're a citizen. And that is something we see in the news a lot today, but it actually arises from the context of Chinese immigration. So just to cap off the history, in 1924, Congress passes a very restrictive Immigration Act, which the way I look at this is taking the plenary power doctrine and the Chinese inclusion case to its logical conclusion. That case said Congress can pass laws restricting or banning immigrants from countries. Courts will be very deferential with respect to those measures. The 1924 Act outright bans immigration from Asia and places severe restrictions in the form of quotas on immigrants from elsewhere in the Eastern Hemisphere. And this hits hard, particularly Jews, Catholics, Italians, and other immigrants from impoverished areas of Southern and Eastern Europe. And as we can just imagine why, if we want to contextualize why this act arose at this time, Europe is smarting from the scars of the World War. There's a lot of poverty and famine going around, and there's a lot of reasons for immigrants to want to come to the United States. So in the face of that, there's a lot of political will to be ultra-restrictivist. So this represents the high watermark of restrictivist immigration policies. It's not until 1943 that the Chinese Exclusion Act is finally repealed. And again, it's not overruled, it's not invalidated by the Supreme Court. It's overruled, it's repealed by another act of Congress. Now to contextualize this, why is this passed at the time that it is? It's because we're in the midst of World War II, and China is a key ally of the United States in the fight against Japan. And so it was somewhat to our chagrin that citizens of our own ally couldn't even legally immigrate to the United States. And so it was a way of throwing a bone to the Chinese government by, at this point, repealing the act. So it's not until 1943 that Chinese people, on the whole, can legally enter the United States. It's not until 1952 that no Chinese Exclusion Act could get passed again, because in that year, Congress passes an act, I think this was mentioned by Ed, that, first of all, it abolishes discrimination in matters of race with respect to naturalization, and it also retroactively takes out all discriminatory language on the basis of race with respect to immigration and naturalization statutes going back all the way to 1790. So it basically cleans up the books in that sense. And finally, in 1965, you have a sweeping act which in many ways represents the modern regime. This act finally undoes the national origins quotas that were imposed in 1924 and replaces it with a 7-category preference system that rejiggers the numbers of immigrations from different parts of the world who can come in. And while the sponsors of the act maintained that it was not going to have a net positive or negative impact on the levels of immigration overall, the fact is, as a result of the 1965 Act, a large uptick in immigration was permitted by virtue of the statute. And interestingly, this is the first time in this entire history of immigration acts that you have restrictions placed on immigrants from the Western Hemisphere, which as we know today is where all the action is. And that comes out of the 1965 Act. And so, just in closing, because I did promise that all this was relevant to today, as a result of the plenary power doctrine that comes right out of the Exclusion Act, today it's good law that Congress can pass acts that restrict people coming from specific places and will be subject to very deferential review by the courts. And Congress can essentially allow greater opportunities for people from one part of the world while simultaneously restricting those opportunities for people from the other part of the world. And that's on the books. And so that's why I always like to delve into the history to understand the present. And I have just a little handout with a few demonstratives that you can peruse at your leisure. So thank you very much.